It gives me great pleasure to introduce Irina Sakharova, who's an assistant professor in commercial law at Durham University, where she convenes and teaches on the contract law and advanced issues in contract law modules, and is taught on the legal philosophy module. Dr. Sakharova's research is situated in private law and legal philosophy, and most centrally in contract law, contract theory, and comparative contract law, and is currently focused on the nature of contractual rights and persons' power to contract. Dr. Sakharova earned her master's and MJur, master's in juris at Oxford. Sorry, I never know what it stands for. Master's in jurisprudence, I guess. Where she was a Hill Foundation scholar. She completed a PhD here at NUS, where she was a graduate research fellow and then an NUS President's Graduate Fellow. Her PhD thesis, Understanding the Legal Power to Contract, was awarded the Wang Guangwu Medal and Prize for the best PhD thesis in her year in the social sciences and humanities. And she's going to speak to us today on consent, promising, and the power to contract.
Thank you very much. Yep, thank you very much for this very kind introduction and for the wonderful opportunity to be back to present my paper, for which I'm very grateful. This paper is part of my bigger project on the power to contract, which develops some ideas that I initially came up with while pursuing my PhD at NUS. It's truly a privilege and delight to be back to present this work here. My bigger project, of which this particular paper is part, focuses on giving an account of the power to contract as a jointly exercised normative power, which naturally also involves trying to explain what the power to contract is not, and that involves contrasting the power to contract with some other relevant normative powers. In moral philosophy, when it comes to understanding how obligations are undertaken in the private sphere, usually if powers are resorted to give an explanation. And most paradigmatically, the power to promise features quite prominently in the explanation of how obligations in the private law sphere can be created. As many would know, moral philosophy, and in particularly the moral theory of promising, has long been a source of inspiration for many contract law projects. Those projects could be said to have had what could be described as a normative focus, so they focus more on the normative side of the matter. As far as analytic endeavors are concerned, it could be said that largely various unilateral normative powers have been resorted to explain the practice of contracting, and those powers are, of course, the power to promise itself, the power to transfer, and the power to consent. This paper in particular focuses on the power to consent and how to distinguish the power to contract from the power to consent. Now, when it comes to understanding consent, it is possible to separate the idea of consent and the normative power to consent. When it comes to the idea of consent, it is an idea that is quite prevalent in many accounts of contracting, but it is often the case that it does not exactly explain what is meant by consent. Consent is often quite loosely understood as related to voluntariness, so the idea of voluntary choice, and more broadly related to the idea of freedom of contract. In many accounts of contracting, consent is taken to be largely synonymous to assent, and sometimes is often used interchangeably with such terms as promise and agreement. So perhaps voluntariness or voluntary choice would be best notions to focus on to understand how the idea of consent is invoked in contract law and contract theory. Now, I do not specifically focus on that side of consent, on the idea of consent. In the paper, I discuss different approaches to how consent can be understood in contract law and contract theory and in moral philosophy more broadly, where it is arguably where the situation is arguably a little bit different in terms of understanding how such notions as consent, assent, promise, and agreement relate. So I register this diversity of opinions in my paper, but in this presentation, I'm going to focus mostly on understanding consent as a normative power, because that is most relevant to my project. Now, when it comes to understanding consent as a normative power, it is important to perhaps flesh out the methodology that I use to rationalize this normative power, and in particular, make explicit some of the premises that are explicit in my paper for the benefit of those who might not necessarily have had the opportunity to read the paper. I'm going to explain what I'm relying on in order to approach the normative power to consent, and I try to rely on an enhanced notion of correlativity in contracting that I have developed in my broader work. Now, when it comes to correlativity, usually it is discussed with respect to the idea of Haveldian dual relations, which can be in relation of correlation or opposition. In my work, I'm supplementing that methodology by with deontic logic and focus on permissions, obligations, and options in order to rationalize contract formation. Now, when it comes to undertaking contractual obligations, and in particular obligations that are recognized as contractual in the common law world, the promissory theories are particularly influential. And if we take a promissory obligation as a comparison, we can see that a simple idea of correlation obtains. We have one party who has a right correlating with the other party's duty, and the duty is usually regarded as the duty to perform what has been promised. Now, this particular relation has attracted some discussion and criticism, in particular in respect to how fruitful it is to use the idea of promise to explain how such an obligation can be created. In contracting and in contract theory, usually the problems that are identified with explaining promissory obligations are replicated, but in contracting, there is also a deeper problem that might not necessarily obtain in promissory relations. In contracting, we obviously have at least two instances of correlation. We have two parties under a duty to perform. We have one party's right correlating to the other party's duty to perform, and the other duty to perform to party's right that the other party performs. Now, if this is appreciated, it becomes a little bit difficult already to say how we can use a unilateral power, such as a power to promise to explain the whole contractual relationship. But I think that we can think even deeper about contractual obligations and correlativity. And even if we separate the two instances of correlation that you can see on the slide and focus only on one of them, we can see a more complicated picture. So if we eliminate then one layer of correlation just for the purposes of this analysis and focus only on one contracting party's duty to perform and the other party's right to that performance, we can see that those rights and duties also give rise to additional dual relations and to an additional layer of correlation, and that is because in contracting, not only is it the case that one party has a duty to perform and the other party has a right that the first party perform, but also one party has a right that the performance is accepted and the other party has a duty to accept the performance. If that aspect of contractual relationship is accounted for, it becomes difficult to use, I think, any unilateral power to explain how a contractual obligation can be created. But of course, in this particular paper, I specifically focus on the normative power to consent and try to apply this enhanced understanding of correlativity in order to explain how power to consent cannot be central to explaining how contractual obligations are created. When it comes to understanding consent as a normative power, and here I am bracketing the broader idea of consent that might not necessarily be linked to the normative power to consent. When it comes to understanding consent as a normative power, we can isolate two particular meanings of consent. Consent as a proprietary gate and consent as a normative rope. Now, those are not the terms that I came up with. I both literature, but the idea of proprietary gate signifies given permission, and we can see it in a potential trespass scenario. If someone gives a license, we can remove a duty not to enter in somebody's land, for example, and in so doing, the owner of the land can open the metaphorical proprietary gate and give permission to somebody's entry, so they would consent to that. And that is arguably a more traditional understanding of consent in moral philosophy, although there is a variety of opinions. However, a different understanding of consent as a normative rope, supposes that one party typically requests something, some action to be performed by the other party, and the other party consents, or we might more naturally say agrees to perform that action and becomes bound to the first party. So this normative rope holds one party to the other party. It could perhaps be said that the idea of normative rope is most relevant when it comes to promising and contracting, because in promising and contracting, we are talking primarily about creating obligations or undertaking obligations. It might be thought that the idea of proprietary gate isn't relevant at all. However, both understandings of consent as proprietary gate and as a normative rope, they have in one way or the other influenced various contract theories, and they have found their application in different accounts of contracting, sometimes implicitly, sometimes quite explicitly. In the paper, I separate, for the purposes of my analysis, the two understandings of consent. The more traditional one, consent as the proprietary gate, and a more controversial, less traditional consent as a normative rope, and then address those understandings separately to try and see whether either of them or both of them could be helpful in understanding how contractual obligations can be created. I started with the idea of consent as a proprietary gate. I've already mentioned that it could perhaps be said, and it has been said in the literature, that the idea of consent as a proprietary gate might not necessarily be relevant at all to the idea, to the practice of contracting, and even to the practice of promising, because consent's primary moral impact is to create a permission, it is thought, whereas a promise primary moral impact is to generate an obligation. So obviously there is a clear difference, and I just would like to register that there is general an opposition in moral philosophy to applying the idea of consent as a proprietary gate to creating obligations. However, if we look at some promissory accounts and in general at many contract theories, we can say how the idea of consent as a proprietary gate has influenced contract theory. And in particular, this idea is prominent in terms of supposing that by entering into a contract, the party who undertakes a contractual duty forgoes some opportunity, and in particular, they abandon some alternative course of action. So they decide not to do what would be inconsistent with what they are undertaking to do under a contract. In the literature, it is sometimes said that the contracting party to be waives their liberty not to do a particular thing that would not be consistent with their contractual duty. Sometimes it is said that contracting party waives or even transfers their right to act otherwise, also in ways that are not compatible with the contractual duties. And I focus on those accounts and ask essentially two questions. First, whether it is fruitful to apply the idea of consent to liberties and not to claim rights. And secondly, I ask whether such an application could be helpful in explaining contract formation. Now, in the paper, I use a relatively straightforward example to illustrate my ideas, and that is an example of a contract between A and B, under which B undertakes to paint A house and A undertakes to pay B for the painting. I'm going to keep the diagrams since they might be helpful while I'm trying to explain what I mean. If we for a moment focus on the traditional case of trespass or trespass to be, where we can safely apply the idea of consent as a proprietary gate, we would have one person who has the right that no one interferes with their property right, and in particular that no one enter their land. So that right would correlate with everyone's duty and with a particular person's duty in question. If they would like to invite that person to visit their property, for example, to have dinner at their home, they can consent to that person's entry, and by so doing, they are thought to remove the duty not to enter, even if consent in this case is revocable. So we can see how, in terms of dual relations, a duty not to enter can be transformed into a privilege to enter, and the right that the other person not enter can be transformed in no right. In terms of deontological proposition, we can see how the invitee acquires permission to enter that would replace their existing obligation not to enter. And if they, well, assuming if they don't have any obligation to enter somebody's property, they would also have the option to enter or not to enter. So when it comes to the trespass example and more traditional application of consent to claim rights and duties, we can see that those situations are easily applicable if we focus on consent as a proprietary gate. Now, returning to my example of painting somebody's car. So if we have a contract under which one person agrees to paint somebody's car, the idea is that they somehow consent to that and waive their liberty not to paint the car. Normally, they do have such liberty just before the contract formation, but it is slightly difficult to explain how their liberty or privilege would turn into the duty to paint the car, because that duty would also be supplemented by the liberty right to paint the car that would correlate to the other party's duty to accept that the performing party paint the car. So we have that extra layer of correlation that I was talking about, and this complication suggests that it's quite difficult to see how by merely waiving somebody's liberty one can come under a positive duty to do something, especially in a contractual scenario where we do not only come under the duty to perform, but we necessarily acquire the right to perform in the sense of liberty right, and that that correlates that with the other party no right that we not perform. So that is slightly technical side of my paper. I think I'm not going to elaborate on that, but I'm happy to take question if any arise from the paper itself. I then move to addressing the idea of consent as a normative rope, and on some accounts in moral philosophy, if we understand consent as a normative rope, that is taken to be almost equivalent or virtually equivalent to promising, and we can see how the idea of consent here collapses into the idea of promising, such as the power to consent and the power to promise almost indistinguishable. Now, if we think about consent as a normative rope, as I already mentioned, the idea of request becomes prominent. Some party is thought to be requesting some particular action, and the other party consents, and the third goes, they undertake an obligation to perform. But just in virtue of the fact that such a model of consenting is very similar to promising, in my paper, I consider very briefly the power to promise separately before returning to the idea of consent as a normative rope. Now, when it comes to promissory theories and using the power to promise, we can see that even if it is not equated to the normative power to consent, we can see how the idea of a rope or a chain is also prominent in many promissory accounts, or more broadly accounts of obligations. There are some rather evocative descriptions using this particular metaphor. I'm not going to go through those descriptions in particular, but I just wanted to register the prevalence of the idea of normative rope in promissory accounts and in accounts of obligations, even if they're not necessarily explained via the consent route. However, if we stay with the idea of consent as a normative rope and think about this idea and use promissory theories and try and understand whether this idea is more fruitful in explaining contract formation two difficulties arise. One difficulty is with explaining how by promising or by exercising the normative power to promise, the party can obtain permission to perform. Once again, in the example of painting the house, if you promise to paint the house, you might be thought to be coming under the duty to paint, but for this duty to exist, it is necessary to have permission to perform, and by merely promising, it's a little difficult to see how this permission can be obtained. Now, if we take those promissory accounts which rely on acceptance as the necessary condition of arising a promissory obligation, one can say that acceptance might be of some help, but I do not think that acceptance helps to address the other problem that arises, because it is difficult still to explain how by promising and accepting one party can acquire a right to perform, a right that their performance is accepted, that would correlate with the other party's duty to accept the performance. So if we focus for a moment on gratuitous obligations, acceptance is usually taken to be based on the negative non-imposition rationale. So you accept somebody's promise and you become the beneficiary of that obligation because it is thought not appropriate to just impose upon someone even the right to somebody's performance. But this additional layer of correlation that I explain, the duty to accept the performance and the right that the performance is accepted, is usually not focused on when we think about accepting promises. And in contracting, this problem is particularly acute. So in some promissory scenarios, we might not necessarily have that additional layer of correlation, but in contracting we always do. So in contracting, it is difficult to resort to the idea of consent as a normative rule, or just to the idea of promising to explain how the obligation is created. So purely promissory accounts, non-contractual accounts might potentially avoid some of the problems that I outlined, but in contracting, it is a little bit more difficult to do so. Now, in the remaining time that I have, I'm going to say a couple of words about possible implications of this argument. When it comes to implications for moral and legal philosophy, the analysis that is conducted in the paper arguably reinforces the doubts about the idea of consent as a normative rule more generally. So what I said about distinguishing consent in the sense of permission and consent in the sense of undertaking an obligation is particularly problematic in contracting, but some of the problems that I discuss in my paper, they arguably help to substantiate some of the doubts more generally about using consent in this particular sense. Perhaps we might need to confine the normative power to consent to granting permissions, and not assuming obligations. I explain undertaking obligations via some other normative powers, such as the power to promise, and perhaps the power to agree, or some other normative power that might be relevant in the context. But in particular, when it comes to contract theory and the philosophy of contract law, the argument that is offered in the paper could be labeled as negative because it denies the importance or even the relevance of the normative power to consent, to explaining contract formation. This negative argument shed some light on why some accounts that rely on the normative power to consent to explain of contract formation might be rethought. And this negative argument, I think, is in itself salutary because it shows some ways in which we could criticize some other reductionist accounts of the power to contract, which would not necessarily be based on the idea of consent, but perhaps could be based on the idea of promising. But moving away from this negative side of the matter on a more positive side, this account, and in particular in my broader work, is a step towards a different account of the power to contract as a sui generis normative power that is exercised jointly and is not reducible to any unilateral normative power. So that is a claim that is obviously not substantiated in the paper because I'm only looking at the power to consent in the paper, but this paper contributes to that broader argument in my broader work. Thank you very much.
Thank you.